Hey there, I'm estate planning attorney Paul Rabelais here, and in this video I'm going to describe a problem that is going to cause many families to pay millions of dollars in estate tax that they would not have had to pay if they had watched this video or otherwise educated themselves. While the word portability may not mean much to you, portability first became a significant estate tax savings tool that became effective for married persons who died on or after January 1st, 2011. You see, back in the day prior to portability, it was a real no-no for a married person to die and leave their entire estate to their surviving spouse. For example, if back in the day prior to 2011, the federal estate tax exemption that each spouse had was $1 million, and a couple had a $4 million estate, $2 million each. If the first spouse to die left their estate outright to their surviving spouse, they would have mistakenly overused the federal estate tax marital deduction, which would have resulted in no estate tax due upon the first spouse's death, but it would have caused the surviving spouse to own the entire $4 million. And when that surviving spouse died, the surviving spouse would only utilize the surviving spouse's $1 million estate tax exemption. The couple didn't get to use the first spouse's exemption because the first spouse lumped their entire estate into the estate of the surviving spouse. Now, back in the day, the adverse tax effect that results from lumping the estate of the first spouse to die into the surviving spouse's estate was avoided by having the first spouse to die leave assets to a trust that would not be included in the estate of the surviving spouse. Then portability was introduced in 2011. And to describe how portability works, let me give you a present day example. Let's say Wanda, the wife, dies in 2023 with an estate of $5 million. Most of which contains her traditional and Roth IRAs, of which she named her husband Henry as the beneficiary, and several other assets that were titled joint tenants with rights of survivorship with Henry. Her estate also consisted of a few assets that were titled in Wanda and Henry's revocable living trust. And at the time Wanda died with a $5 million estate, her husband Henry had his own $10 million estate. And now, because the bulk of Wanda's estate was left to Henry through beneficiary designations and survivorship titling, Henry wound up with all of the $15 million in his estate. At this point, Henry's feeling pretty good. Wanda died with a $5 million estate. Wanda's estate tax exclusion amount was $12.92 million, so there was no requirement that Henry file a federal estate tax return on behalf of Wanda's estate because her gross estate of $5 million was less than the $12.92 million exclusion amount. So Henry lives for, let's say, 7 more years and dies in the year 2030. His estate grew from $15 million when Wanda died in 2023 to $23 million when Henry died in 2030. Now here's where we have to make an assumption. Let's assume that when Henry dies in 2030, after sunset provisions and inflation adjustments take effect, Henry's estate tax exclusion amount is $10 million. But Henry died in 2030 with a $23 million estate and only a $10 million exclusion amount. So the excess $13 million will be subject to a 40% federal estate tax, and Henry's estate will owe $5.2 million to the IRS within 9 months from the date that Henry died in 2030. Now let's switch it up just a bit. Let's say that after Wanda dies in 2023 with her $5 million estate she left to Henry, even though no federal estate tax return is required to be filed, Henry files a federal estate tax return in order to make a portability election. You see, by Wanda's estate going outright or directly to Henry through IRA, life insurance, and rights of survivorship designations, Wanda's estate didn't use any of its $12.92 million estate tax exclusion amount. But by Henry filing an estate tax return after Wanda died and making the portability election, Henry's estate will be able to use not only his $10 million exclusion amount when he dies in 2030, But Henry's estate will also be able to use Wanda's unused $12.92 million exclusion amount, allowing Henry's $23 million estate to shield $22.92 million from the estate tax when he dies in 2030. This portability election resulted in only $32,000 of estate tax to be due after Henry dies, instead of $5.2 million in estate tax had Henry not made the portability election after Wanda died. So why are so many couples and families going to miss out on this tax break and face having to pay several million dollars in estate tax that could have been avoided? Mainly because they don't know about it. Many estates these days are set up in a way so that no estate lawyer involvement is required upon the death of the first spouse to die. And that's great. What surviving spouse wants to have to deal with lawyers while grieving the loss of their spouse? When the first spouse dies, no lawyer involvement is required because assets either pass directly to the surviving spouse through beneficiary designations, or assets are in a living trust and the lawyer and court involved probate is not required. So there's no one there to let that surviving spouse know, hey, Henry, you're not required to file a federal estate tax return now that Wanda has passed, but doing so and making the portability election will allow your estate, Henry, to shield an extra $12.92 million from the 40% estate tax when you die down the road. The good news is that in 2022, the IRS issued a revenue procedure that allows estates to elect portability of a deceased spouse's unused exclusion amount as late as 5 years after the death of the first spouse to die. You see, normally an estate tax return is due to the IRS within 9 months after someone dies. But the IRS extended the deadline for estates that are not required to file an estate tax return but want to do so to make a portability election. They extended that deadline to the 5th anniversary after the first spouse dies. The reason they extended this deadline to make a portability election is that so many surviving spouses were unaware that this opportunity exists and they were missing the deadline. Bottom line here, if you're a married couple with a few million dollars or more, be aware that an opportunity exists to save millions of dollars in estate tax, but it is going to require the action of filing a federal estate tax return and making the portability election after the first spouse dies.